One of the telephone calls I probably take 4 or 5 times a day is people calling me up saying, "Richard, I want to get my record expunged. Richard, I want to get my record non-disclosed." And they don't know exactly what they're asking for, they're dealing with, they just want it off their record. The law is very distinct between the two methods. An expungement is a erasing or destruction of the record in essence. But you have to have very specific outcomes to achieve that. If you receive a not guilty from a judge or a jury, you're eligible to receive it, and you're eligible to receive it immediately. If you receive a dismissal, if that dismissal is given with prejudice, which means that the district attorney cannot bring the case anymore, and they've basically abandoned the case, you can get it immediately. However, if they dismiss your case without prejudice, you're not able to receive an expungement until the statute of limitations on the crime you're accused of has passed. Unfortunately, for certain crime categories, child sex offenses, murder, there is no statute of limitations on it, so you can never get your case erased in those particular instances. Now, on the other end, there's what is called a non-disclosure. Non-disclosures is where you actually have received a probation, a deferred probation. You have lived out that probation, either the entire probationary period or been released early, and then there is a cooling off period or a waiting period the court wants you to do to make sure you don't commit any other crimes before approaching the court to ask for this record to be sealed. That's the difference. One is a destruction, one is a sealing of the record. In addition to that, the courts sometimes by a matter of fact will grant the motion, but other courts in other instances will need you to prove up that there's a specific need because you're suffering a harm, like not being able to rent apartments or receive jobs. It doesn't need to be an actual harm, but a potential harm. But it's very important that you understand what type of crime category you had, what type of exit that you received on your case, either for an expungement or a non-disclosure, and also what your waiting periods are. The expungement and non-disclosure process was intentionally designed to be confusing. It was designed by a gang of bureaucrats, and they want you to go basically through a legal maze that either you're going to quit halfway through or you're going to be so frustrated that you're going to mess up on your paperwork and be denied. So what do we provide here in this firm? We handle hundreds of these type of issues a year. We have our staff who's been trained on filing proper petitions. We know the time constraints, we know the limitations, we know the proper coding. And so what can we do? We can cut right through the issue and get the results that you need. The process takes time though. We're at the mercy of the court. And so at first we're going to have to look at your record to see if you're qualified. Then the next process is filing the case, getting it in front of a district judge. And then the most important part is trying to get the district attorney not to object so that we can basically have what is called a summarial granting, or not speaking lawyer, the judge simply signs the motion. Once we receive that, some people become frustrated because it doesn't go off their record right away. And as I tell everybody, the government is a big, gigantic moving brontosaurus. The court's not expecting them to comply with magic just like that. So cities are going to get a 30-day grace period to comply with the court order. Counties are going to get 6 months, and the federal government's going to get up to a year. After that point, if they fail to remove the record, either through an expungement order or a non-disclosure, they subject themselves to fines. If you run yourself into this situation, get lawyers who know how to handle this defense.